Section 164. Pay now, argue later principle. SARS issue an assessment for 8 million rand, as in one of our cases, completely baseless, completely incorrect, but they want him to pay straight away. If he does, he's probably going to have to close down his business. If he closes down his business, you have 62 employees with families that will no longer have a job. This is based on an assessment that should not have been raised, that is incorrectly raised, but SARS want the money now. Now let's say they don't adjudicate. Sometimes in my experience they take 6 months, maybe even a year to adjudicate an application of this nature, which is fine with me, because in that period they cannot take any collection steps. But they do, often, even though 164 is in place. And what do we then have to do? We have to go to SARS, we have to tell them a 164 is in place. If you don't stop with your collection steps or return those funds that you just took, despite the 164 being in place, we're not going to pay you 8 million rand now. We don't have to. The money you took, or half of that you just took from the account, please give it back. They don't. You have to bring an application. You have to bring an application to get those funds back within 48 hours for your client, failing which you should ask yourself, are you adequately protecting your client's rights? This is, for me, a typical example. There's nothing in it for me to punt a product like, for example, tax risk. But this is a typical example for me where it becomes a no-brainer. Where a taxpayer pays 200 rand a month, or 600 rand a month, depending on the threshold, Willem, or 1,000 rand a month, and in a situation like this, you have attorneys, and whether it's us, whether it's someone else, it doesn't matter. You have tax attorneys and accountants on beck and call to launch an application of this nature and protect the taxpayers' rights. So we have this matter, 8 million rand case, as to whether it should be a retrenchment or not. If I can just use that as an example, we'll probably get into the tax court 3-4 years down the line. If everything goes well, then 1 or 2 years down the line. 30 days into this dispute, this matter could be disposed of. Because if they fail to give me my reasons, I'm going to use Section 129, and I'm simplifying this for you guys to save time. Do a 129 notice, give them 15 days to comply with my request for reasons. If they don't, I'll bring an application for default judgment, and I'll ask the court to confirm my objection. Or I'll ask the court to confirm my original assessment. That's the end of the matter, right there. Filing these default judgment applications, however, even if you do it on a contingency cost order basis, meaning you don't charge your client but get SARS to pay the costs, that's an extreme exception to the rule. The fact of the matter is the bill needs to be footed. And this is where I personally, as a tax law practitioner, find exceptional value in a product like tax risk management. In fact, I'm dumbfounded how every single taxpayer and every single auditor accountant is not giving this policy to taxpayers to use for the purposes that I'm setting out today.